I actually started giving these speeches and traveling around the country speaking to people because 6 years ago, that's when I started speaking, there was a woman in my county, in my backyard, who was being starved and dehydrated to death, a disabled woman. And Congress passed a law expanding the jurisdiction of federal courts so that they could hear cases like hers. And I heard people yelling and screaming, Congress can't do that. Well, yeah, it can. Congress controls the jurisdiction of the lower federal courts. Well, also inherent in that is Congress controls the funding for the lower federal courts. In fact, for all of the courts, all federal courts, including the U.S. Supreme Court, Congress controls that funding. And the only thing in our Constitution that says Congress has to do is they have to pay the judges and justices what we've agreed to pay them. It doesn't say they have to pay them anything else. They don't have to pay for light bulbs or security or limousines. And in fact, our U.S. Supreme Court did not have its own building until 1935. Before 1935, our U.S. Supreme Court held court in the basement of the Senate. And if you go to Washington, D.C., you can tour that room where they used to hold court to this day. Well, did you notice, what is the tenure of a federal judge or justice?
Good behavior.
Good behavior. Yeah, but what does the media tell us? Lifetime, right? What does the Constitution say? Good behavior. They hold their office during good behavior, and we're going to talk about that in just a few minutes. Well, if there was anything in that section that surprised you or you didn't remember, I think maybe this next section is going to shock you. Article 3, Section 2 deals with the jurisdiction of the Supreme Court. And it talks about a whole bunch of different kinds of cases, which I'm not going to read to you. You need to read for yourself. And then it gets to this paragraph. In all cases affecting ambassadors, other public ministers and consuls, and those in which the state shall be a party, the Supreme Court shall have original jurisdiction. Those are the cases you never hear about. Original jurisdiction means that's where the court, that's where they first bring their case. That's when the Supreme Court is the trial court. You never hear about those. And then it says, in all other cases before mentioned, which you have to read the cases listed, the Supreme Court shall have appellate jurisdiction. Those are the ones we always hear about. A court or courts have made a decision, and the Supreme Court is going to review that decision, right? So the Supreme Court shall have appellate jurisdiction, both as to law and fact, with such exceptions and under such regulations as Congress shall make. In other words, Congress controls the appellate jurisdiction of the U.S. Supreme Court. Did you know that? Here it is. It's in your Constitution. Okay, I have one more section I'm going to read to you that has to do with what we're talking about tonight, and that's Article 6, the last paragraph. And as I just said before, the different articles deal with the different branches of government. Article 6 deals with the legislative branch. In the first part of it, it talks about how old our U.S. representatives have to be, and how long they can serve, and how they're elected, how old our U.S. senators have to be, how long they can serve, and how they're elected, which has changed, as you know, which we can talk about afterward. And then it gets to this paragraph. The senators and representatives before mentioned, that's the U.S. senators and U.S. representatives, and the members of the several state legislatures, and all executive and judicial officers, both of the United States and of the several states, shall be bound by oath or affirmation to support this Constitution. That's what a constitutional officer is. From our supervisor for elections all the way to the President of the United States, both state and federal all take an oath to support this Constitution. This written Constitution, the oldest written Constitution in the world. They do not take an oath to support the Constitution they wish we had. They don't take an oath to support the Constitution they made up in their own heads. And they don't take an oath to support a decision about that Constitution. And I'm going to go into great detail as to what that means. Well, as you know, we declared our independence. We told the whole world, we're not the lawbreakers. You King of Great Britain, you're the lawbreaker. And here's all the reasons and all the ways that you have violated our rights as Englishmen, correct? And then we fought a 8-year, bloody, costly, miraculous war of independence. Then we came up with, it took us a long time, we came up with our Constitution, right? And then they presented the Constitution to the states, but the states didn't want to ratify it. Why? Because the states had just paid a very dear price to get out from under tyranny, and they weren't willing to give up that kind of power, even though it's supposed to be a very limited power, up to a centralized federal government. And so 3 men, Alexander Hamilton, John Jay, and James Madison, wrote a series of papers explaining the Constitution in great detail and promoting its ratification. And these papers today are called the Federalist Papers. And if you have ever read the Federalist Papers, there are several things that should really jump out to you. One of them is that our founders really believed that our Republican form of government, our electing, not electing, re-electing, not re-electing our representatives, was our greatest protection against tyranny, including tyranny of the majority, which is what a democracy is, a mobocracy. They thought that was our greatest protection against tyranny. They also believed, and for that reason, they made all 3 branches of government accountable to the people, contrary to what you will hear a lot of people say. They'll say the judicial branch is not accountable, it's independent. That's not the way they made it. I'll explain all that. And also, if you read this, read these papers, it becomes very, very clear that our founders purposely made the judicial branch to be the weakest branch of government. Maybe because of what we just read in the Declaration of Independence. They don't say that though, but I don't want you to take my word for it. I'm going to read to you from Alexander Hamilton's, this is Federalist Paper number 78, and this is what he says about the judicial branch. The judiciary, from the nature of its functions, will always be the least dangerous to the political rights of the Constitution, because it will be the least in a capacity to annoy or injure them. The executive branch not only disperses the honors, but holds the sword of the community. The legislature not only commands the purse, but prescribes the rules by which the duties and rights of every citizen are to be regulated. The judiciary, on the contrary, has no influence over either the sword or the purse, no direction, either the strength or the wealth of the society, and can take no active resolution whatsoever. It may truly be said to have neither force nor will, but merely judgment, and must ultimately depend upon the aid of the executive arm, even for the efficacy of its judgments. It proves incontestably that the judiciary is beyond comparison the weakest of the 3 departments of power. And I'm going to illustrate what that means as we go along. Well, as you know, the states did ratify the Constitution. We did become these United States of America, and we went on fabulously for a few years, and then the U.S. Supreme Court came up with a decision, an opinion, that law students have to study to this very day in law school. It's 1803, it's called Marbury versus Madison. And in this decision by the U.S. Supreme Court, there was one particular sentence that has played havoc in this country ever since. And this is the sentence. Here's what it says, quote, "It is emphatically the province and duty of the judicial department to say what the law is." In 1907, Justice Hughes turned that sentence into this sentence, quote, "The Constitution is what the judges say it is." Contrast that to Sir William Blackstone. Here's what Sir William Blackstone said, quote, "Court opinions are evidence of the law, not law themselves." We know that. We learned that in elementary school, remember? The legislative branch makes the law, the judicial branch applies the law, and the executive branch enforces the law. Under our judicial system, under our common law system of justice, 2 people have a conflict, and they can't solve it between themselves. And so they go to court. And their conflict, their controversy is unique. They're unique people, it has unique facts, unique circumstances. You know, we're all different, we're all crazy, we all have our little intricacies. It's unique. And those people will come to the court, and they either pay a lawyer to do this. This is what we learned to do in 3 years of law school. They either do it themselves or they pay a lawyer to argue to the court, you know what, this case is just like this other case. So you should make this decision the same as this other case. Or this case is different because, so you should make a different decision. And it is the judge's or the jury's job, sometimes the jury's job, it is the judge's job to take the law and apply it to that particular unique case or controversy with its unique people, unique facts, unique circumstances. And the judge comes up with an opinion, a decision as to how the law applies to that particular case or controversy. And that opinion that that judge gives, that decision he makes, is only binding on those people that are in that case or controversy. And it's only enforced against them if the executive branch decides to enforce it, because the judicial branch can't enforce anything. It is never, that opinion or evidence or decision about how the law applies to that case is never the law. The judicial branch can't make law. And it's especially never the law of the land. Have you heard that said about certain U.S. Supreme Court decisions? It's the law of the land. We're supposed to all know that the judiciary cannot make law. Well, who was president in 1803 when this decision came out? When Marbury versus Madison came out? Nope. Jefferson, 1803, our friend Thomas Jefferson. And here's what Thomas Jefferson had to say about the whole hoopla. Quote, the opinion that gives to the judges the right to decide what laws are constitutional and what not within their own sphere of power, not only for themselves in their own sphere of action, but for the legislature and the executive also in their spheres, would make the judiciary a despotic branch. Indeed, to consider judges as the ultimate arbiters of all constitutional questions is a very dangerous doctrine indeed, and one which would place us under the despotism of an oligarchy. The Constitution has erected no such single tribunal. And here's how it played out during Thomas Jefferson's presidency. If you'll remember, right before he took office, Congress passed the Alien and Sedition Act. The Alien and Sedition Act, in part, made it illegal for anybody to utter seditious libel against the government. And so the federal government was busy doing what we'd all love to do today, rounding up newspaper editors and throwing them in jail. Well, the Congress passed this law, Alien Sedition Act, and the U.S. Supreme Court said, constitutional. And Thomas Jefferson said, absolutely not constitutional. And he pardoned everyone who was ever convicted under that federal act. That is what the executive branch power of pardoning is. It is supposed to be a check and a balance on the other two branches of government. It is supposed to be a check and a balance on the legislative branch and the judicial branch. It is not for cute little impeached presidents to pardon their criminal cronies, and that we shouldn't be allowing that to happen. Well, here's another example of how the system of checks and balances is supposed to be working. Andrew Jackson was a good example of this. When Andrew Jackson was president, Congress repassed an act establishing the Bank of the United States. Meaning, the federal government would not only be busy taking our money, it would have our money in its bank. And Congress had passed this act establishing a Bank of the United States, and the U.S. Supreme Court had said constitutional. And Andrew Jackson said absolutely not constitutional. And he vetoed it when it came back during his presidency. He vetoed it on constitutional grounds. And here's what